My Lords, when your Lordships rose yesterday afternoon, I was addressing you on UKTC's ground 3, and as you know, the headline submission that we make is that the CAT's decision to prefer the RHA was a multifactorial assessment with which this court should not interfere. There was no error of law. And as I said yesterday, UKTC make 5 main points under ground 3, the first of which was that the CAT erred in failing to follow the guidance of the Supreme Court and this court in the various recent cases. And I had just dealt with merits and explained why the submission based on merits was rightly described by the CAT as misconceived. And if I can now go through the other cases relied upon, and if I may, I don't intend to take your Lordships to the judgment. I don't want to be responsible for pushing us into a third day.
No. Well, as I said yesterday, if we have to sit tomorrow, we have to sit tomorrow. I don't want anybody to feel under pressure.
I'm grateful. My Lord, I think notwithstanding that, I can take these points relatively quickly. Sure. The submission based on Lloyd and Google, we say, doesn't take matters anywhere.
It's a different regime.
Well, A, that, yes, my Lord, different regime. B, it was considered by this court in Le Paturel, and I'll come to that in due course. But C, paragraphs 25 to 32 are the relevant paragraphs in Lord Legate's judgment. He's talking about a different regime. He's also talking about difficulties in group litigation where there are issues with practicability and difficulties in relation to take-up and convertibility. And we say that's just a million miles away from what's happened in this case. Because
those were the only points in that judgment where he was referring to this regime, wasn't it, by comparison with the group action and the CPR.
Exactly. And also paragraph 25, what he has in mind are difficulties with opt-in actions where claims are worth a few £100. And you had my submission yesterday. The RHA say their case is worth £10,000 per truck. So with respect, Lloyd and Google doesn't assist. Le Paturel, however, does assist what we're submitting. And can I just explain, we rely on Le Paturel for really three parts of the judgment are significant.
Yeah.
The first is paragraph 55 to 57.
Where is it in the...
It's Joint Authorities, volume 4 and tab 39. Which that maybe it's volume 3, tab 39.
I think you've got different. Oh yes, you've got different. It's 7, I think. Volume 7. Volume 7.
Oh, I'm sorry, Michael.
29.
Tab 39, and there are 3 aspects of the judgment which I would just highlight.
55 to 57.
Yes, 55 to 57 is the passage in my Lord Justice Green's judgment dealing with the point I made yesterday that I started with, the scope of the appellate jurisdiction. One sees the heading at paragraph 50, and we rely in particular on 55 to 57, which I won't read out, but your Lordships will see that this court should not interfere with a weighing exercise. The tribunal has exclusive jurisdiction over collective proceedings and so on. So we rely upon that. We also rely upon, over the page, the section 60 through to 68. And again, I referred to this yesterday, but this court considered an argument, actually both sides in that case were arguing that there was some statutory presumption. One was saying a presumption in favour of opt-in, the other saying a presumption in favour of opt-out. And this court rejected all of that. And one can see in 68 in the conclusion, there's no prior legislative predisposition one way or another. So it's all ultimately a question of discretion for the CAT. And at 73 to 83, just draw your attention to those paragraphs. 73 to 74 is really the conclusion on the facts of Le Paturel, where this court said at 73 the CAT was entitled to conclude that if an opt-in was ordered, the take-up could be very limited. It seems to us to be a more or less obvious conclusion to arrive at. Both judgments demonstrate practicalities might favour an opt-out, where there are large numbers of potentially affected parties and relatively small sums at stake, which might otherwise deter the take-up of opt-in proceedings. And the reference to those other cases is Lloyd and Merrick's. And then 74, towards the end, the CAT came to specialist conclusions which lay squarely within its broad margin of judgment. There is in our judgment no basis in law upon which this court can properly interfere. And you'll see in 78 an expansion of the reasons why the CAT considered that an opt-in was not practicable in that case. And essentially we say the logic applies equally here, albeit the other way around, because the CAT has considered that an opt-in would be practicable in this case, and there's no grounds for this court to interfere with that assessment. And if I may say, when your Lordships, Lord Justice Green and my Lord Justice Flo put to Mr. Thompson yesterday that Passerelle was completely different and you didn't have in mind the sort of case we have here with a trade association, £10,000 a truck, and thousands of claimants, all he said, well, he had no answer. He just said to your Lordships, I don't want to waste your time. So he hasn't actually got any sensible basis, we say, for suggesting that the CAT fell into some error of law here. He does make a point both in writing and orally yesterday that the CAT in our case in fact adopted a presumption in favour of opt-in, and we say that's misconceived. The CAT specifically says at 223 there is no presumption, and it conducts a perfectly proper balancing exercise. And the final authority, appellate authority that's relied upon is the Gutman case, and since we have the authorities open, I'll just show you the one paragraph that's relied upon. It's the next tab. And it is said by UKTC that it is surprising that the CAT did not refer to this guidance, they say, from Gutman. Now, Gutman postdates the CAT's judgment, but also paragraph 39 is irrelevant to the issues that we are considering. If one looks at 39, the question the court was considering in that context was whether, in a claim for aggregate damages, causation and liability would also be considered on an aggregate basis. That is the question of interpretation of section 47C2 with which this court was concerned. And one can actually see, if one goes back to paragraph 27, just to put the point beyond any doubt, 27 Roman 1 shows what the issue was. And so the submission yesterday from Mr. Thompson was that Gutman 39 shows the serious case management difficulties for opt-in cases where individual damages are being claimed, and we say that is just not a correct reading of Gutman 39. So overall, in relation to this first point on the appellate authorities, we say there was no error of law. And if I can just sweep up in here, the reliance that's now placed not on a further appellate authority but on Royal Mail, what's said in UKTC's skeleton, this is paragraph 65, they say the Royal Mail judgment now illustrates the practical impossibility of such a claim for any but the largest businesses. So they say this is support for the idea of an opt-out. Now, it's not clear, but what we think they're referring to is paragraph 690 and also 732, where in the context of the pass-on debate in Royal Mail, the CAT observed that claims by BT and Royal Mail's customers might not be viable due to the anticipated small monetary size of those claims. I don't want to take up time by showing you those paragraphs, but essentially we say those paragraphs are irrelevant. First of all, it's concerned with a different question, because the issue here is whether individual claimants would opt in to the RHA action. That's the practicability question. It's not whether individual claimants would bring individual claims. So they're actually asking themselves the wrong question here, the UKTC. But in any event, what Royal Mail was concerned with were downstream customers bringing claims which were worth a few pence. And one can see that, if I can give you the reference to that, that's paragraphs 556 to 559, 572 to 573, and in the dissenting judgment, but on this point it doesn't matter, it's 705, 729, and 732. There are references in those paragraphs to...
Give me the second reference again. 555, 559.
572 to 573.
Yeah.
And then 705, 729, and 732. And that section of the judgment on pass-on is replete with references to how minuscule or tiny those claims would be. And as I say, Mr. Ridyard says that they are worth a few pence, so it's completely different to this case. So that's the first of the 5 points, and I'll try to take the remainder relatively quickly. The second point is expert evidence, and I foreshadowed this submission yesterday because they criticised the tribunal's preference for the methodology of Dr. Davis over Dr. Lillico. And as your lordships know, we say there was no error of law here. It's perfectly legitimate for the tribunal, with its expertise, to weigh up the 2 methodologies, looking at both the written and oral evidence of the experts. And on the basis they had significant concerns with Dr. Lillico, they were entitled to prefer the RHA's opt-in action. And we also say that having preferred the expert methodology of the RHA, that was a proper factor which outweighed the potential benefits in the abstract of aggregate damages. So that's really the answer on expert evidence. And in this connection, UKTC point to Royal Mail again, and they say, look, Royal Mail shows that the cap was wrong because Royal Mail shows that a regression methodology doesn't work. And we say that is a hopeless submission with respect. Paragraph 479, which is the paragraph that Mr. Thompson went to yesterday, simply says that no regression model could reach a definitive solution, was I think the point being made, i.e. this is not a perfect science, but that, as I think my Lord Justice Green pointed out yesterday, nonetheless, the cat was able to wield the broad axe. And the cat, in our case, rightly notes at paragraphs 125 and 216 that regression methods are well tested and widely acknowledged. So there's nothing in the point that Royal Mail suddenly demonstrates that Dr. Lillico's simulation methodology is preferable to the regression, or at least there's no error of law by the cat.
I suspect there must be a difference between measuring the relative strengths or otherwise of experts at the certification stage than at trial. I mean, the Royal Mail Tribunal was quite rude about the expert evidence in those paragraphs you cited. But I mean, that's with the benefit of hindsight, having had the best part of a month and a half's worth of trial. What the cat has to do at the certification stage is its best efforts to get its head round whatever it is that's before it. It's bound to be an imperfect exercise, but that's the nature of the beast.
Exactly so. And what's more, my lord, on the principle that what's sauce for the goose is sauce for the gander, if I can just give you the reference to 487 to 503 in Royal Mail, because there's a discrete aspect of the Royal Mail case, a so-called complements argument, where DAF put forward a simulation model, and that was entirely rejected by the cat in Royal Mail. So the idea that, I think Mr. Thompson was saying that Dr. Lillico has been spectacularly vindicated, I think was his phrase yesterday, because of the Royal Mail judgment. With respect, that is a total misreading of what happened there. And it certainly doesn't read across, as my Lord Justice Green's just said, to the weighing up that was going on at the certification stage. So that's the second of the 5 points. The third is data, and they say that the tribunal was wrong to prefer the RHA action on the basis that there would be more data available. And I'd just like to start by showing you exactly what the cat said in relation to data. So if I could ask you to turn up the judgment.
Yeah.
First of all, paragraph 132. So one sees in 132 a reference to Dr. Davis's evidence and the sample exercise carried out on 42 proposed class members. The sample exercise showed that a significant degree of relevant information is likely to be available. And even if only a minority within each subclass has some of the information, the large numbers overall mean the class members should yield a significant volume of data points which can be used as a basis to predict missing values. And they describe that as a rich data set which should enable Dr. Davis not only to estimate the primary equations, but also to test many propositions of fact that have already been raised by the OEMs and disputes which can be expected to arise. And then by contrast, if one turns ahead to 143 in the section where they're considering Dr. Lillico's proposed methodology, you'll see the quotation from the Commission's practical guide at the beginning of paragraph 102. This example is particularly demanding in terms of data requirements and assumptions. Simpler simulation models may be envisaged to estimate damages, but they rely even more heavily on crucial assumptions. And then 148, again, in relation to Dr. Lillico's methodology, there remains the more general concern about the degree to which the methodology depends on assumptions, or if reliance on assumptions is to be limited, the extent of data required. And then, importantly, 150 over the page, about halfway down, Dr. Lillico, further, he envisaged that a limited data set could be compiled from a sample of class members. That is challenging for an opt-out class action, where, as he himself put it in his third report, the approach to quantification must recognise that a large number of claimants will not be in a position to submit data during the proceedings, even if a subset of claimants can and does do so. And then just to follow this through into the later analysis at 223, so this is now in the section where they are making the choice as between the two CPOs. At 223, for the present claims, opt-in proceedings have the notable advantage of giving the expert economists access to a very significant source of data from the claimants to inform and support their quantification of estimated damages. So that's how the tribunal dealt with the availability of data. And UKTC make a number of criticisms of the tribunal's approach. So if I can just run through the various points that they've made, either in writing or orally. First, they describe the close relationship between the RHA and individual proposed class members as illusory. That's 78 of their skeleton. And at 79, they say there's no reason to believe that the RHA class members will hold usable or systematic data in a common format, or that it would be feasible for Dr. Davis to undertake a review. Now, we say in relation to that, it's just pure assertion. They don't give any basis to substantiate what they're saying about this so-called illusory close relationship. On the contrary, as I've just shown you, the CAT was satisfied based on the 42 proposed class members sampling exercise. The CAT was satisfied that there would be a rich data set available to Dr. Davis in due course. So no error of law there. The second point, they say, well, there's no legal barrier. So UKTC themselves accessing data, and Mr. Thompson took you to the McLaren case to say there's no legal bar to disclosure by class members in the context of an opt-out. But the tribunal didn't proceed on the basis that there would be no data available in the context of the opt-out. On the contrary, as I've shown you at 150, the tribunal acknowledged there may be a limited data set available, but Dr. Lillico himself was saying it may be a challenge in the context of an opt-out. And we say that's obviously right as a matter of common sense. An opt-out, much harder to obtain data from proposed class members. The third point is again reliance upon Royal Mail, and they say in their skeleton the suggested advantage of the greater availability of additional data has been shown to be a fallacy by the experience in Royal Mail. That's paragraph 78 of their skeleton. Now, again, we say they are misreading Royal Mail, or their reliance upon Royal Mail is misplaced. They rely in particular upon paragraphs 336 to 339, and they say that there, the experts agreed that a market-wide overcharge analysis was more reliable. But it's clear that we submit that even if a market-wide overcharge analysis is to be carried out, data from the claimants will be of assistance. Now, I've shown you paragraph 132 of the judgment, where the CAT said that claimant data could be used to test propositions of fact raised by the OEMs. But what I can also give you are references to Dr. Davis's reports, where he explains that data from the class members would be a useful complementary source, and he describes it as a valuable source of data about transaction-specific characteristics. And if I could just give you the references, Davis 1, paragraphs 50, subparagraph C, 58 through to 77, 94B, 140, and his second report, paragraph 354, which is where he says proposed class members are likely to be a valuable source of data about transaction-specific characteristics. And so we say the tribunal was entitled to reach the conclusion that the richer data set in the RHA action was a factor which weighed in its favour. Fourthly, in relation to data, UKTC make the point in writing, this wasn't made orally. They say, oh well, there are all these individual actions going on, and even in the UKTC case, all of that data will be made available. But that would be the case if it's correct, which we don't necessarily accept. But even if that is right, that would obviously be the case in relation to both UKTC and RHA. So it's not a factor that weighs in their favour. And the fifth point, which they don't make in writing, but as a new point made yesterday, Mr. Thompson relied on the Supreme Court's judgment in Merricks and says, well, that shows that the considerations of data are irrelevant. Now, with respect, the point in Merricks was completely different. And if I could just explain that. In Merricks, the issue was that there were going to be data issues whether the claims were brought either on the conventional basis as individual claims or through the collective regime. And the point the majority made in Merricks was where there are these data issues, the court's going to have to wield the broad axe, and that shouldn't be a basis for refusing certification because the data issues would arise irrespective of how the case was brought. But nothing in the Supreme Court's judgment precludes the CAT at the certification stage from preferring RHA's action over UKTC's on the basis that there will be a richer data set available. So we were surprised to see the reliance upon Merricks yesterday for the first time. Now the fourth main point under ground 3, they criticise paragraph 74 of their skeleton. They criticise the tribunal for taking what they describe as an inconsistent approach insofar as the tribunal noted the additional cost and complexity of 2 overlapping CPOs, but on the other hand, failing to take account of the clear guidance of the Supreme Court and Court of Appeal in recognising the savings in costs associated with a single aggregate award. Now, we say there's nothing in this for 2 reasons. First, this argument is premised upon a misreading of the appellate authorities, and I've been through those and I won't repeat the submissions, but there's nothing in the appellate authorities which say that aggregate damages are always to be preferred. But secondly, it's clear from the CPO judgment in this case that the CAT did have regard to the potential simplicity and efficiency of an aggregate award damages. That's paragraph 215, which I showed you yesterday. So they were mindful of that, but they concluded that the RHA's expert had a superior methodology. So that fourth point under ground 3 we say is devoid of merit. And then the fifth and final point is in relation to funding. And paragraph 67 to 68 of the skeleton, and Mr. Thompson made this point yesterday, they describe this as a major advantage of the UKTC application. And the major advantage, they say, is that the RHA funding arrangements will give the funder the right to recover in priority to the sums payable to the class members, whereas UKTC's funder, on an opt-out basis, will only recover out of undistributed damages. And they say that's a major advantage, and they say that this constitutes an error of law by the CAT. But can I show you how the CAT dealt with this? Because again, the CAT was very conscious of this point, considered it, and rejected it as being something which tipped the balance. So if one looks at 224 in the CAT's judgment, see the heading funding arrangements, and you'll see it at 224. It's exactly the same argument that they were making before the CAT and they lost on. They're just repeating the same point. At 228, you'll see at the final sentence of 228 that they regard this as a relevant consideration. And 229, they say we consider that it's necessary to consider this in concrete, not abstract terms, which we rely upon. In other words, the CAT was looking at this point on the facts of this case. The CAT then goes on to consider the terms of the RHA funding arrangements and also the RHA and UKTC's estimates of overcharge per truck. And you'll see at 230, about a third of the way down, based on the figures that the RHA and the UKTC themselves are putting forward as to overcharge, we do not consider that there is here a realistic concern that the remuneration arrangements with Therium may operate unfairly as regards the class members, or that if their claims are successful, those class members are likely to be deprived of a significant part of their damages. And then they go on to say they should be slow to reject opt-in proceedings where they are otherwise preferable on the basis of the funding arrangements. So again, we say no error of law there. Now, my lords, can I deal with ground 4,
Yes.
which I hope to take relatively briefly?
Just before you do,
Yes.
just for my interest, why do you care about any of the points you've made?
Why?
What gives your clients as respondents to these proceedings the right or interest to make the sort of points you've just been making in relation to which, as it were, opponent you should face? I would understand it if you were complaining about funding insofar as it might be available to meet an adverse cost order. But just to take the last point, which was dealing with the question about what's in it for the members of the class, I sort of feel like I'm in a sort of parallel universe where the respondents to these sort of claims have a right to make submissions about which opponent they ought to be facing throughout the proceedings, with a sort of perverse incentive to ensure that they face the least able claimant.
Well, my lord,
Would I be wrong in thinking?
well, just taking that in stages, the funding point, you're right, but in a sense, once the tribunal's talking there about the protection of the class members. I'm obviously just dealing with arguments made by UKTC under ground 3.
Well,
So,
I know you are. I know you are.
no, but the funding, no, there's a broader point. There's a broader point which your lordship's raising. But I think funding is a slightly discrete issue because I understand the point you're making in relation to funding. That may be an issue as between class representative and class members. But leaving aside the funding issue, there is a broader point which your lordship's putting to me, and the simple answer is we are respondents to the collective proceedings.
I don't doubt. I listened with interest and pleasure to your arguments, and I don't doubt that you are a respondent. But I'm sort of coming to these type of follow-on damages claims from sort of slightly outside the tent, if I can put it, sort of, compared to my colleagues on the bench, and I've been struck by both a couple of weeks ago and this week, listening to you, that this is a strange way of proceeding at a preliminary stage where, and it's not a personal criticism, but it's been particularly one I wanted just to raise. Why should the respondents have a say, if you like, on matters which don't actually relate to their own interests in, for example, making sure that their own costs could be met by an advert if there was an adverse cost order? Why should that be part of the process that the CAT engages upon at a preliminary stage, where what it's doing is simply certifying a collective proceeding and choosing between two rival carriers of the proceedings. You know, what should be the role?
With respect, my lord, the certification stage is an important, as you know, the court has this gatekeeping role, the screening role. And with respect, what your lordship, the logical consequence of what your lordship's putting to me is that defendants should have no ability or interest in the certification process.
No, it's not.
No, it's a different point.
Well,
because I think the point the point my lord has in mind, and I have a tendency to agree with him, is that if you of course, where you have a choice between two class representatives and one of them has a methodology which simply doesn't satisfy the Microsoft test, for example, that's one thing. Where the tribunal has said, in effect, that both of them do satisfy the Microsoft test, but preferred the RHA to UK Trucks, then one does sort of wonder why the respondents are so keen that it should be the RHA rather than UK Trucks, and in circumstances where the whole thrust of the submissions you made this morning is that there was no error of law in the choice they made. But it seems to me that and I'm, again, not criticising you at all, that a lot of the points that you made really are points for Mr. Flynn to say, well, actually, we're better for the following reasons, and the tribunal didn't get any of this wrong.
but it's not as simple as the carriage dispute. I can understand the question if one was looking at a pure carriage dispute, which I know your lordships heard the FX appeal, and I can see that might actually be a different situation. But here, of course, on the table, as it were, UKTC are putting an option whereby they proceed instead of RHA, and also an option where they proceed in parallel with the RHA. So there are actually various permutations. And with respect, it is obvious that the defendants or proposed respondents do have an interest in the shape of the litigation going forward.
The scope of the claim, I suppose.
The scope of the claim. I mean,
Okay, so I understand why certain of the issues do affect the respondents. Now, I actually focused on a different one on, for example, costs.
Yes.
Because it's a clear point that if the issue was, are the claimants adequately funded to meet an adverse costs order if they lose at the end of the day, in other words, are you going to get paid your cost? I see entirely. And if you say something on that, I would understand it, whereas in fact the submission you made was all about how benefits might be shared out as between the members of the claimant's class, which you would have thought, given that you're just on the paying end of that, you have little to say. And that was just an illustration. But what I'm sort of concerned to understand is the fact that there is a perverse incentive, it might be thought, in this Machiavellian world we live in, for the respondents to ensure that they face the least coordinated, least structured, least persuasive claimant, rather than the best, most well-organised and best constructed claimant. In other words, put it another way, you might quite like to face the least capable expert rather than the most capable expert. And I'm struggling to understand whether it's right in those circumstances for the respondents to all have their say at this certification stage, because what we have seen both a couple of weeks ago and to some extent this time is vast quantities of material produced and a sort of an early fight going on about who's the best expert.
Well, with respect, funding and costs I would like to put in a slightly different bucket, because I completely understand the point your lordship's making, and indeed that is reflected in some of the authorities where defendants have taken points about funding arrangements and said, well, you shouldn't be authorised as a representative. I think the CAT has actually said, not really sure this is a point that should concern the defendant. So I completely accept what you're saying to me on the funding and cost types points. But on the broader point, which I think is important, and is important not just for this case, but going forward, with respect, we would submit it is in the defendant's interest to ensure that the litigation, which is going to be of a large scale, moves forward in a structured and coherent way. So, for example, if I take the point about an opt-in will lead to greater data from proposed class members, it is in our interest to ensure that the methodology at trial is done on the basis of proper or better data, so that all of that can be worked through. and we're faced here with a situation where one claim is an opt-out with a methodology which just scraped over the line, and Mr. Harris will make submissions about that, limited data set, according to the expert, and in contrast, we have a trade association on an opt-in basis. It's new and used trucks, so this is not all entirely self-serving. It's a new and a used trucks case.
If one were being cynical, Mr. Secretary, not of course that the court is ever cynical, but if one were being cynical, one would say, well, actually the defendant's best interest is to have UKTC and Mr. Lillico, or Dr. Lillico, who appears to have been less impressive than Dr. Davis, so far as the CAT were concerned. And therefore, from the point of view of the defendants, it might be said there's more prospect of the whole thing collapsing and losing.
But that, with respect, demonstrates why this isn't totally Machiavellian, because we're not standing up saying, oh, we'll let through Lillico and UKTC because we'll knock them out of the park at trial. We're not saying that. We're actually saying the CAT was right to prefer the RHA, even though the methodology was said to be superior. And I do submit the logical consequence, my lord, of what you're putting to me is that the defendants don't really have an interest at certification at all, because it's not in the defendant's interest to face a collective action. So you could say, well, why are you turning up at the certification stage saying this methodology doesn't work? That's a matter purely between the class representative and the tribunal. And we say that is the wrong approach. It's reflected across the world that defendants do have a standing in the certification question, not just whether it should be certified, the basis of certification, and here, whether it should be one or the other.
I'll make my last point just before you move on to sort of issue 4, but we've seen that the certification process seems to be developing into quite an elaborate enterprise, very costly, with large amounts of rival expert evidence, perhaps even exchanged at an early stage between potential claimants and potential class representatives and the respondents. Is that the right way to go in terms of making these proceedings cost effective and straightforward? And is there anything what can the CAT do to sort this out by filleting out?
Well, the CAT has actually said something about this at the end of its judgment.
We had the same point in FX, the FX trading case a fortnight ago.
Exactly.
The sort of what I think we described, I'm not sure anybody else did, as a sort of quick and dirty point. That there's a lot to be said for certification being dealt with in a sort of quick and dirty way at an early stage.
We would respect
what we seem to have got is sort of an accretion of expert evidence and data and hearings that last for almost as long as a trial would normally last. Just at the certification stage.
We would respectfully agree with that sentiment, which is precisely why we're saying on ground 3, this is a rolled up hearing. And we would actually say this is the kind of point that permission should not be granted, because what UKTC are doing is inviting your court to rerun what was a 5-day hearing in front of a specialist tribunal. So insofar as this is a rolled up hearing for your court, for your lordships to provide guidance in relation to future cases, this is the opportunity to say nothing that they have put forward amounts to a point of law. Permission should not be granted. That's exactly the point we're making.
Okay, anyway, we've probably berated you enough, Mr.
No, it's all taken in the right spirit.
Ground 4.
Ground 4, rather less fundamental. The primary position on this, just to again break this down, we say, and as you know, Daimler say, that through the respondent's notice, that they shouldn't have satisfied the process criteria, UKTC, and Mr. Harris will address you on that. If that's right, then it follows that UKTC should be dismissed altogether. So this question of a stay doesn't arise, because the stay could only be relevant if they're above the threshold. Now, again, one needs to break down precisely what they're saying here. They seek a stay, although they floated at one stage a stay generally in the event that the RHA action may be decertified or fall over at some point. Their position is rather more limited and realistic now. So now they say, we'd like a stay pending the opt-in notice period in the RHA to see whether the RHA action will actually be viable. And they also say a stay in the alternative pending the funding judgment from the Supreme Court. And I'd like to just deal with this separately. So if we leave aside the funding judgment, which I'll come back to deal with, because these points raise different considerations, we say there should be no stay. Leave aside the funding judgment. We say there should be no stay for essentially two reasons. One is we do say that it's too late to run this point, and I'll develop that in a moment. But secondly, we say it's wrong in any event, and if this point had been raised before the CAT, it would have been readily dismissed. Now, we say it's too late because, notwithstanding that Mr. Thompson prays in aid that these proceedings were commenced in May 2018, notwithstanding that the proceedings lasted, I think, 3 years in front of the CAT, it never occurred to UKTC to raise this point, and we say they're not entitled to complain before this court for the first time that the CAT erred in law, which is what they accept they have to show, erred in law in failing to exercise the CAT's discretion in a particular way, which the CAT wasn't invited to do. Now, there's obviously a wealth of authority on the question of when this court hears new points. And as you know, there's a spectrum. I think one of the judgments in the bundles is my Lord Justice Snowden's judgment in the Notting Hill Finance case, I think. But there's a spectrum, and at one end you have points which require evidence, and at the other end are points of law. And we say this point is neither one nor the other. What we have here, as I say, is a criticism that the court below made an error of law by not exercising its discretion in a particular way. And the only authority...
It's really difficult, isn't it, if you don't invite the CAT to do something, to say, well, they erred in law.
in
not taking the point themselves.
Exactly. And we've actually
the
found...
highest it could be put really is, well, maybe if the CAT had thought about it as well, they'd have said, well, hang on, then, wouldn't it be a bad idea to have wouldn't it be a good idea rather to have a stay?
Exactly, and we say...
It can't be said that that's an error of law.
Exactly, my lord.
And it's a question of discretion.
We've managed to find an authority which just supports that proposition. It's the Allen case, which I believe is tab 72. I hesitate to give you volume numbers.
No, it's actually, yeah, it's volume 12.
I'm grateful. And it's obviously a very different context, but it's the principle is directly relevant.
Yes.
So one sees Lord Justice Lloyd's judgment, and its appeal, as I say, a very different context, I accept that, but this was an appeal brought against an order requiring the claimant to pay into court substantial sums, into court with the sanction that if any of the sums were not paid, then the action would be struck out. And you'll see at paragraph 2, the claimant complains of 3 things: the amount, the fact that it was made as an unless order, and thirdly, the order for costs. And then if one skips forward to paragraph 15, you see Lord Justice Lloyd saying, a noteworthy feature of this appeal is that each of the first 2 grounds relies on a point not argued below. And the final sentence of 15. The argument, therefore, is the judge misdirected himself in the exercise of his discretion, even though he was not addressed on the point, which he is said to have got wrong by overlooking it. And then in 16, there's the point about, well, if new evidence is required, then that would be a fatal objection, and I accept we're not in that territory. But could I ask your lordships to read 17, please? Because that makes the point that it's rather curious and difficult to accuse the CAT of an error of law, we say, in reliance on this paragraph.
Let's just read that then.
I should draw your attention to 18, where he says, I do not intend to adopt any hard and fast rule, but he views with considerable scepticism the attempt to criticise the judge, not taking a point into account which was not submitted to him as being relevant. And he says maybe the reason why it wasn't the subject of submissions is because it's not a good point. And then what he does on the facts doesn't really matter. We say exactly the same analysis applies here. There's a discretionary decision that the CAT had whether to stay or dismiss. It chose to dismiss. It wasn't asked to stay. So it is very difficult, we say, for UKTC now to describe that as an error of law. But in any event,
It's even worse than that in a way, isn't it? Because, as it were, the obvious course to adopt when an application fails is to dismiss it.
exactly.
And if the party who loses doesn't suggest a different course to the court, the CAT, it's very difficult to say that the CAT somehow exercises discretion in a way which could, in any sense, be regarded as an error of law.
Exactly, Michael. It's worse than that because they put in very lengthy submissions after the judgment in terms of the consequential matters. And this wasn't even raised at that stage. And it's a classic discretionary case management decision, whether to stay or to dismiss. But in any event, my lord, we say it's a bad point because insofar as they're saying there should be a stay until the expiry of the notice period, we say what they're really doing is questioning whether the RHA will in fact have enough members to opt in. What they're really saying is we'd like to wait in the wings and resurrect our application if we take the view that not enough members have opted in to RHA. And with respect, we say this is a bad point because the tribunal has already made a finding that the RHA opt-in proceedings will be practicable and viable. That's a decision that hasn't been challenged, the fact that the RHA action will be practicable. That was all based on the evidence of Mr. Burnett. And all that UKTC can say is, well, the RHA's book building efforts and the evidence that was before the CAT in terms of take-up was on the basis of a class definition that had to be amended and on the basis of a slightly different run-off period. But with respect, the tribunal would obviously have been mindful of its decisions as regards class definition and run-off period when it was considering Mr. Burnett's evidence and practicability. And so what they really did...
It was a class of 16,500 and that there was going to be a notice going out which meant that the class might increase to even more than 16,500.
Exactly.
So it's a completely different case from the sort of, on practicability, from the sort of issues that this court was considering in the FX funding case, where if it was opt-in, then it wasn't going to happen at all because nobody was going to opt in.
Completely different. Exactly so. And that's why we say they shouldn't have a stay until the end of the RHA notice period, because the question of whether the RHA is practicable has already been decided. And a new point, a related point that was made for the first time yesterday, Mr. Thompson said, well, there might be some issues with the drafting of the notice. There was some exchanges with my Lord or Justice Snowden about whether the notice and the RHA might need to be tweaked. And he says, well, that, who knows whether that drafting will ever be fixed, and we need to stay until at least the notice has been finalised. And with respect, the idea that the RHA action won't proceed because of some drafting issues is fanciful. So we say in relation to the stay for the RHA opt-in notice period or the drafting of the notice, it's too late to bring that point and it's hopeless anyway. But we do accept, my lords, if I can turn to the funding judgment, we can see in relation to the funding judgment from the Supreme Court that's still pending, although Iveco itself is not a party to the funding appeal, we do understand that it's correct, at least in theory, that there are various potential outcomes because either the funding arrangements of both UKTC and RHA might be said to be compliant, or they might both be said to be in contravention of the rules, or one could be fine, that UKTC say they might be fine, but RHA might not be. So we can see that there are a range of permutations, and therefore what we would respectfully suggest is that we don't know when the Supreme Court judgment is coming out. We also obviously don't know what this court will say about the various grounds of appeal and the various consequences in terms of remittal and so on. So what we respectfully suggest is that we deal with this point pragmatically, which is once we have this court's judgment, we can address you to the extent necessary and to the extent there's a dispute about the interaction between these proceedings and the funding judgment. It may be, for example, that the funding judgment is out by the time this.
When was that appeal heard by the Supreme Court?
It was last year. I don't think it was
On the 16th of February, Matt, or 16th of February this year, wasn't it?
This year.
This year.
I apologise, it's February this year. But there just are, as I say, there's a range of permutations in terms of what might happen post the Supreme Court. There's a range of permutations in terms of what might happen after this court's judgment. And we also don't know in terms of the timing, how the two will interrelate. So we, just to be pragmatic, we say we could deal with this by way of consequential submissions in writing once this court has handed down its judgment. My lords, unless I can assist further, those were my submissions on grounds 3 and 4.
Thank you very much,
Morning, my lords. I appear on behalf of Daimler, and it's my job to address the respondent's notice grounds on behalf of Daimler and Iveco. And just before I remind you of what they are, can I address Lord Justice Snowden's point as to why am I doing it? And perhaps a handy way is just to remind you of a passage. You don't need to turn it up in the minority judgment in Merrick's in the Supreme Court, Lord Sales and Lord Legat. It's paragraph 98. And what it says is that these collective actions are, quote, also capable of being misused. The ability to bring proceedings on behalf of what may be a very large class of persons without obtaining their active consent and to recover damages without the need to show individual loss presents risks of the kind already mentioned, as well as giving rise to substantial administrative burdens and litigation costs. And then a key point, the risk that the enormous leveraging effect within such a class action device creates may be used oppressively or unfairly is exacerbated by the opportunities that it provides for profits. So on the broader question that was addressed by Mr. Singler, whose submissions I also adopt, there is a legitimate interest on the part of the defendants not to be unfairly oppressed by an action of this gargantuan type that is represented by UKTC. And all the more so, we say, where the methodology is insufficient or inadequate, and I'm about to address that. Just to remind your lordships, if you were to turn up in the skeleton argument bundle, our skeleton, it's the final tab, and this provides you with a handy reference point to the respondent's notice grounds. There are two. So this tab 5 of skeleton arguments, our paragraph 5, which is page 137. And we raise 2 points. One, we say failure as to the analysis of common issues under Rule 79(1)(b), so that's 5A.
Yeah.
And secondly, failure properly to apply or direct itself as to the Microsoft process test. I tend to call it process, but Microsoft, it's the same point.
Yeah.
And just to address the suggestion that was made by my learned friend Mr. Thompson that neither of these respondents' notice grounds raises an issue of law, I'll just sweep that one, if I may, out of the way. In Merrick's in the Supreme Court, so this is on the common issues point, you will recall that one of the points that went to the Supreme Court was as to the question of common issue. And what they said at paragraph 64A, again, you don't need to turn it up, is, and I quote, "The cat's got the common issue question wrong in relation to merchant pass-on, ... That was an issue of law." So that's the end of my learned friend Mr. Thompson's objection on my respondent's notice ground 1. My ground that I'll develop in a moment is that they got the common issue question wrong as regards downstream pass-on. And that is an issue of law. You may not agree with the submissions, but it is an issue of law. And then secondly, the point is I'm going to be criticising the application or direction of the CAT towards Microsoft process, and that's been on the appellate route on a number.
That's an issue of law as well.
That's an issue of law as well. So if you don't need to see any authority on that, the best reference is, of course, the judgment of which 2 members of this court sat in McLaren at paragraph 9.
We were struck by the fact that quite a few Court of Appeal cases, PAC as an example, doesn't really analyse the approach that the Supreme Court took to defining a point of law in Merrick's. When you actually categorise each of the issues which the Supreme Court addressed, a lot of them are treated as points of law, including points as to the relevant approach to be taken, inferences to be drawn from common ground facts, those sorts of things, all were treated as points of law. And as everybody knows, we have to, at some stage, get our heads around the difference between appeal and judicial review. And I don't think it would be a secret for anybody who's watching FX to think that we're not certain there's a great deal of difference between the two in terms of standard, and we're not anxious for people to spend a lot of time worrying about that, albeit that we've got to resolve it. But I think the concept of a point of law is relatively broad.
But, my lord, yes, I agree. What I would, of course, contrast it with is, and again adopt Mr. Singler's submissions, with a weighing exercise. That was the language of the court in Goodman. And what is quintessentially a weighing exercise is the one that Mr. Thompson sought to attack, namely, should I choose this one over that one? There's relative benefits of this one compared to disadvantages of that one. That is a classic weighing exercise and multifactorial. That is not a point of law. In contrast, is there a common issue? Did you get that wrong? Question of law. And though not quite as hard-edged, did you properly direct yourself as the Microsoft process, and did you apply that properly? I do accept that, again, as per Gutman, this is in your Lordship, Lord Justice Green's judgment, I think at 61, this is when I, as it happened, was criticising the survey evidence in that case before the majority of this court. It was said, well, there is a degree of discretion and judgment there in assessing the evidence, and therefore it's a high hurdle. It's not an impossible hurdle, but is it? And I accept that. I don't shrink from it, but I do accept. So that's what I have to say about why it's legitimate for me to be making these points, why they're issues of law. And I just finished my introductory remarks, and it may be convenient for the court if I do the introductory remarks and then the first ground before the transcribers break, and then and they're interlinked, my two grounds, in this sense that both of them have a degree of focus upon downstream pass-on. My first ground is all about downstream pass-on, saying that's not a common issue. The second ground criticises the methodological approach and says it shouldn't have even scraped over the line. And I have 4 criticisms there, and one of them is downstream pass-on. So they are interlinked in that sense, but they're nevertheless separate. In my respectful submission, I could win on one or win on the other. I don't need to win on both. Either way, there'd be an error of law that would be relevant to how this matter then gets dealt with at the end of this hearing. And lastly, by way of introductory remark, the two grounds are related in this sense. Although I don't have the burden of explaining or seeking to explain why the CAT may have gone wrong on the methodological approach, my second ground, why it got, although I don't have that, I don't have to explain why, I just have to say there's an error in my respectful submission. In my submission, the point that I'm going to develop on Respondent's Notice Ground 1, the incorrect assessment of downstream pass-on, in part does explain why there was an insufficient scrutiny of the methodology on that point. So, Respondent's Notice Ground 1, as I'm going to say, they didn't appreciate fully what was involved in downstream pass-on as a common issue, and that may well explain why the methodology wasn't sufficiently scrutinised when I get to Ground 2. So those are the introductory remarks, and may I just then turn straight to Respondent's Notice Ground 1. So to be clear, and with great respect, the CAT got a great deal of this right, and I have absolutely no issue with it. What I would invite you to do in the core bundle is turn up tab 17 and maybe keep the bundle open, because this is the judgment of the CAT below, and I'll be going back to this on several occasions. But it got a great deal of this right, and one example of where it got it right was paragraph 50 of the CAT judgment. What it says there, having discussed some of the Canadian case law, is that there must be a sound methodology for resolving the issue on a common basis. Whether the question of the expert methodology is integral to the finding of a common issue or a separate matter to be addressed under the heading of suitability may not matter. And critically, if there is no plausible method of addressing the proposed common issues on a common basis, the claims are not suitable for collective as opposed to individual proceedings. And we respectfully agree, that's correct. And there are similar sentiments in paragraphs 74 and 80, so no problem so far.
And you say that's a good illustration of where a respondent does have a legitimate argument to make, about the shape of the proceedings they have to face.
Precisely so. To some extent, and again, this is very far from Machiavellian, we're assisting the tribunal because what I'm going to go on to develop at the later stage on RN2 is that nobody wants a claim that fails to meet some basic procedural methodological safeguards, then collapses later, post-certification, when a great deal more money has been spent and other people have been excluded from access to the court resources for a longer period. You don't want that. So we have an interest in that not happening.
Except, hang on, I mean, the respondents would quite like ultimately not to pay anything.
Yes, but what we don't want is a situation where we're, for lack of a better verb, vexed for another 6 or 12 months until what we said at certification was it will collapse. And then it takes 6 or 12 months and X million pounds for it to have collapsed.
Hang on,
One thing we say for sure, it'll be more than 12 months.
wait a minute. Are you seriously saying to me that the respondents here would be aghast if in 12 months' time this all went away?
No, but I'm saying they would be a lot happier if it went away at certification because what we said about the methodology being flawed, we hadn't had to wait another 6 or 12 months until that stage where it becomes even more obvious.
You'd rather not put the champagne on ice.
We'd rather not put the champagne on ice, is one way of putting it, my lord.
But
In my case, always the case.
But then it has to be, I mean, at certification stage, I mean, you can't have as it were, a mini trial.
No, absolutely, I accept those strictures.
It has to be a relatively short task that the CAT is engaged upon at certification, because otherwise the whole thing becomes a sort of a pre-trial of a trial.
I accept all of those strictures, absolutely. It's not a mini trial, all of those things that are said, including in merits in the Supreme Court. Luckily, of course, despite the fact that there is concern, understandably, on the part of the court about some of the developments in this jurisdiction, we're a long way away from, for example, the US, where you have these certification disputes that could last for weeks, with cross-examination of the expert having been informed by a very full disclosure exercise beforehand. So it's not the end of the world, but I'm not suggesting that I dispute anything that your Lord Justice Snowden has just said. What I am saying is the CAT got that part right, and with great respect to the CAT, if we were to turn in the same judgment to 155, as another key element of the analysis that it got right, and this ties in very much with the substance of Respondent's Notice Ground 1. There's the wider question of pass-on as a mitigation defence. As discussed above, we do not think this can be ignored, simply because it's a matter to be raised by the defendants once the collective action goes forward. That was Mr. Thompson's position below. I don't have to deal with this. It's a defence, nothing to do with me. To the contrary, the CAT concluded that if the defendants can establish on the balance of probability that pass-on is likely to occur, it is not for them to produce a method by which this effect can be quantified on an aggregate basis. In order for the proceedings to be suitable, it will be for the class representatives to have a method of adjusting the aggregate damages claimed. It is therefore appropriate to consider this now. And we, with respect, entirely agree that it was their burden in an aggregate top-down opt-out claim, and they failed to meet that burden, as I shall show principally under Respondent's Notice Ground 2. But there is one other point that I'd like to just emphasise from this paragraph, which is that it is a type of mitigation defence, and the CAT recognised that and got that right. And this point then emerges even more clearly in a passage that I respectfully suggest is key from the judgment for the purposes of this ground, which is at paragraph 81. So just as you turn up 81, my learned friend Mr. Thompson, on behalf of UKTC, did not address downstream pass-on. The CAT said it should have done. But it also then addressed what had happened in the RHA claim on the question of downstream pass-on, and it deals with it in 81. So the RHA action is different. Aggregate damages are not sought, and only opt-in proceedings are proposed. And then skipping down, it's the next third sentence. As the RHA action involves individual awards of damages, it would be possible to approach this on a more individualised basis once the primary loss is established. And then a key passage, since in effect it addresses the question whether that loss has been wholly or partially mitigated, and then even more key, the next sentence, the focus when it comes to pass on is entirely on the PCMs, that stands for proposed class members. And it could be approached, for example, by considering PCMs in different commercial sectors. Now that could happen in the RHA claim, but of course the critical difference is in the RHA claim, this is almost the key theme of my respondent's notice ground 1. The focus, as the CAT rightly says, is entirely upon the PCMs. The RHA, A, you know who they are, B, they've opted in, C, they can give you data, and D, they are engaged. They are, by definition, engaged, otherwise they wouldn't be there. But every single one of those 4 points contrasts with UKTC. You don't know who they are, they haven't given you any data, they aren't engaged by definition, and you therefore can't have a focus entirely upon the PCMs. You just can't do it. And what we say is that the CAT went wrong, with great respect to the CAT having got these other parts completely right, essentially just above this paragraph at 80. And it's the first sentence. And this is where we say the conceptual misdirection essentially occurred with respect. Merrick's demonstrates that pass-on, however...
Which paragraph?
It's paragraph 80, the top of the same page. Merrick's, so the CAT says, demonstrates that pass-on, however much it might vary as between members of the class, will be a common issue if it can be addressed on a common basis. And that's where we say the error arises, because what it does is, with respect, it conflates a Merrick's type case, which is not downstream pass-on, with a case of downstream pass-on, which is our case. And the difference is very much on that sentence, 6 or 7 or 8 lines down, 81. The focus when it comes to pass-on, by which it means downstream pass-on, is entirely on the PCMs. So let's just cast our mind back to Merrick's. Merrick's was a case of an indirect end consumer class. By definition, there can't be any downstream pass-on from an end consumer class. They're at the end of the chain. There's nobody to pass on to. So there was no argument in Merrick's about problems.
But the argument was a different argument, which is
It was-
whether or not the retailers had passed on to the consumers.
It was precisely so, and that's critical, because let's ask ourselves the question, my lord, upon whom does one focus on the question of pass-on to somebody downstream? It's the person doing the pass-on.
Well, it's Sainsbury's or whatever.
Well,
I know it's not Sainsbury's there, but I mean,
it could be,
it goes
actually.
back to what we dealt with in the Court of Appeal and then the Supreme Court dealt with in Sainsbury's.
Absolutely it is, and I'm going
A very
to...
different species of pass-on to the one that we're...
My lord, you have the submission. When I get to Sainsbury's, I will take that quickly, because you have exactly the point. Who do we focus on when it comes to something going to the end consumer downstream class? It's the people above them. It's the Sainsbury's, the retailers of this world. So you have to ask yourself, is there a plausible, credible, realistic methodology looking at them? Not looking at the 46.2 million end consumer members of Merrick's. So nobody did. It was a non-issue, complete non-issue. But in this case, who does one have to focus on? One has to focus on, in Mr. Thompson's claim, the opted out members. And I just ask rhetorically, who are they? Does he know who they are? He hasn't got the faintest idea. Has he ever spoken to any of them? No. Has he got any data from any of them? A point I'll develop later. No. And as we will see in Sainsbury's, my Lord Justice Flo, this is a heavily fact-dependent question. I'm going to come to that. You have to focus on them, because the question of how that person passes something on downstream is very fact-dependent. So I'll develop that in a minute. But just to finish off on Merrick's, I know you're very familiar with this, so I don't need to turn any of this up. What was said in Merrick's is, take a look at paragraph 118 of Process Microsoft. We're all very familiar with that. But what you will recall, and it's cited in our skeleton at 13 and elsewhere, is that says in terms that all one has to do as an end consumer class, an indirect purchaser class of the 46 million Merrick's type, is all you have to do to get past the procedural certification stage is have a methodology that plausibly shows any degree of pass-on to anybody anywhere at the indirect purchaser level. Right? That's all you have to do. It says it in terms in paragraph 118, and that was expressly reconfirmed in the Supreme Court of Canada in the Godfrey case that we also cite in the skeleton. That's all you have to do. And you ask yourself why? And the answer is quite straightforward. It's because this is largely a procedural hurdle. Have you done something procedurally that won't later collapse? And have you got a prima facie case as a bunch of claimants that some loss has reached your level of the chain? That's why you just need to show some degree of loss to anybody, anywhere at that level. And as it happens in Merrick's, we did. We did have a methodology, and it was accepted as being realistic and plausible to show at least some degree of loss to somewhere in that
point,
chain.
isn't it? Once you show some degree of pass on to some people, by definition, in that sort of case, you're showing a vast amount of pass on to a large number of people.
Yeah. The precise amount to be determined at trial, precisely so. And does it advance the litigation, to coin a phrase both from the Canadian courts and from Gutman, from the court's judgment in Gutman? The answer is it does, because let's say the methodology then fails at trial. Well, it advances the litigation because it shows that nobody's ever going to get a penny. But equally, it could be that it advances the litigation because you're able to prove it in some sectors or at some time periods or not at others. And so in Merrick's, it was a different case for the reasons that I think I've just explained and to some degree we've acknowledged. But it's very important that to recognise that in this case, we're not focusing on a situation where all that one has to do is show, for the purposes of the claimants, any amount, anywhere, at that stage of the litigation. To the contrary, as I've just read out from the judgment, this case had to deal with not only overcharge arriving at the level of the commercial purchases that my learned friend Mr. Thompson hopes to represent, but it also had to deal with what happened in relation to the defence that is going to be run by the OEMs. It simply had to deal with what then happens to any overcharge that may have arisen at that stage. And the reason it had to do so is because otherwise the methodology was materially incomplete. And there would be major problems procedurally for an aggregate top-down claim if all it could do, plausibly and credibly, was establish some degree of loss by way of overcharge reaching that level, but it couldn't plausibly or credibly deal with what then happened to that overcharge. That would be a recipe for potential disaster because the case may just collapse. And it's important to note that in this country, in contrast to what is said at judgment paragraph 81, because it's an opt-in claim, the RHA, you could conceivably have a common issues trial that establishes the overcharge. And as the CAT says, it could then lead to a more individualized basis once the primary loss is established, i.e. potentially individual trials. I'm not saying it would, but it could in an opt-in, where you're doing bottom-up.
The reality is it would be bound to deal to some sort of sampling
Precisely, I don't.
at some stage, but I follow the point. Yeah.
But the reality, of course, is do you do that in an opt-out claim? No, you don't. And indeed, the CAT, in none other than Gutman, made this point at paragraph 108.2. And could I just show you that judgment on this issue? So it's in Authorities tab 30, which in my case is in bundle 2. And I think that may be bundle 6 for you. And it's at paragraph 108.2, which is internal page numbering 1313. And as your lordships know, there are some similarities between Canada and the UK, and there are some dissimilarities. And this one is a dissimilarity. The approach of the Canadian courts, I'm reading from sub 2, has frequently been to segment the proceedings between a common issue trial to be followed by trials of the individual issues. And of course, Canada only has opt-out claims.
Yeah.
But that's not, although that's certainly possible, it is not expected to be the approach where the class representative puts forward a tenable claim for aggregate damages. In other words, in Mr. Thompson's proposed action, we're not looking at, in all likelihood, some kind of segmented or bifurcated trial. And even if we were, since his is an opt-out aggregate top-down claim, he would still need a methodology that deals with downstream pass-on an aggregate opt-out
We'll
basis.
come back in an opt-out case at the level of distribution in some way, shape or form, so you don't avoid it altogether.
It might. It might, because as this court has made clear, there is a massive degree of flexibility at the distribution stage. And as Merrick's made extremely clear, what you cannot have is a backdoor refocus on the individuals or individualized distribution when the approach at the preceding stage of liability and quantum has been under section 47C2 to disregard, if that's the way the methodology works. It might not, but if it did, you can't bring it in by the back door. And of course, that's what was the criticism of both this court and the Supreme Court of the CAT judgment in Merricks, that by, at the distribution stage, saying there had to be a more compensatory, this was Mr. Hoskins' argument, he said, hang on a minute, a distribution, you can't, it would be too, it doesn't respect the compensatory principle, and that was wrong. That was wrong. With great respect to Mr. Hoskins.
Not much respect.
I don't want to relitigate that particular point. Anyway, the point is that one has to weed out at the certification stage, in my respectful submission, cases in which there is a major procedural problem, and this case is a major procedural problem because of the failure properly to understand and conceptually analyse downstream pass-on with the principal focus, or quote, entire focus upon the members of the class, in comparison with Merricks, where that point just didn't arise. And so making good progress on this point, if I could just turn up the Sainsbury's, as I said I would, in the Supreme Court, Lords, and that's in tab 27 of the, I think the same bundle of authorities. Actually, number 5, I'm told. And this, as I say, I will very deliberately take quickly. The first paragraph I'd like to just show you is 193 of the judgment and 199 of the Supreme Court. So that's to be found on pages 1157 and 1158. And these are very straightforward. They just say that the submission was, this is the second sentence of 193, that direct loss is prima facie measured by the extent of the overcharge, and then the court agrees at 198. I beg your pardon, 199. We are satisfied that the merchants are correct in that submission, that they're entitled to plead as prima facie loss, measure of their loss, the pecuniary loss measured by the overcharge. But of course, the story doesn't end there when there's a defence of, by way of mitigation of downstream pass-on. As the court says 2 paragraphs above, in 197, there are sound reasons for taking account of pass-on in the calculation of damages for breach of competition law. Not only is it required by the compensatory principle, but also there are cases where there is a need to avoid double recovery through claims in respect of the same overcharge by a direct purchaser and by any subsequent purchasers in a chain to whom an overcharge has been passed on in whole or in part. So you have to do it for very good reason. As it happens, I don't need to show you this, but in the supplementary bundle, there is an example of a claim of downstream truck users, people who engage in transport services. So people downstream having already made a claim in the CAT. So you have to do it for good reason, both in principle and in practice. But the key section
Which case is that?
It's called A to Z, and I'll give you after the short break. I'll give you the reference. There's a claim form in, I think it's in tab 22 of the supplementary bundle. One aspect of which is claim for transport services using the supplies of allegedly overcharged trucks. But more critically is what the court in the Supreme Court says in Sainsbury's about the factual nature of this downstream pass-on, where, as we know, there has to be the focus upon the proposed class members. So picking it up over the page at 205, this is a passage that we'll all doubtless be very familiar with, the final line of page 1159 in paragraph 205. There are 4 principal options for how a retailer could react. And then it sets out the options. I don't need to read those out. But the next page, which option or combination of options a merchant will adopt, this is a little b, a capital B, a merchant will adopt will depend on the markets in which it operates. Well, there's a factual question. And its response may be influenced by whether the cost was one to which it alone was subjected. Well, there's a factual question. Or was one which was shared by its competitors? Well, there's another factual question. And then in 206, it says again that that's a question of mitigation of loss. And this question of it being one of fact is expressly drawn out 2 pages further over at 1162. This is in paragraph 215 of the judgment at letter C. And at letter C on the right-hand side, you'll see that the relevant question is a factual question. Has the claimant, in the course of its business, recovered from others the costs of the, in that case, merchant service charge, including the overcharge contained therein. The merchants, having acted reasonably, are entitled to recover their factual loss. And then 216, second sentence. But once the defendants have raised the issue of mitigation in the form of pass-on, there is a heavy evidential burden upon the merchants. So that's to provide evidence as to how they have dealt with the recovery of costs in their business. So what I draw out from this is you have to have this clear focus when it's a question of downstream pass-on the class members. It's a heavily factual question, depends on all kinds of things that are unique to those class members upon whom you're giving this entire focus. And it being a factual question with a focus upon them, they have a heavy evidential burden. None of that arose in Merrick's, right? So those cases, that case didn't deal with the point that I'm making. The point that I'm making is essentially very simple, is you represent people in the middle of the chain who are going to pass on according to us. So your methodology has to cope with the law of the land, which is that your members, there has to be a fact focus upon them, and they have an heavy evidential burden. And my very simple point is that where was your methodology that dealt with that issue? It doesn't exist. It simply doesn't exist. And with respect to the CAT, having set up the founding building blocks so correctly, it was led astray in that passage at the beginning of paragraph 80 because it drew too much reliance upon this case of downstream pass-on being akin to a Merrick's type case, which was not downstream pass-on. And there's a critical difference. So the key issue on Respondent's Notice 1 is therefore, how was an aggregate top-down methodology for an opt-out class whose members are not even known going to deal with the law of the land as set out in Sainsbury's of the Supreme Court? It had to do that, and it didn't. Just to finish off this point before pausing for a short break, this can be tested in another way. It's important to note that there were two other attempts by UKTC in its certification application to put forward heads of loss that were fact dependent, that required a clear focus upon the claimants themselves. And they were, on the one hand, compound interest, and on the other hand, emissions. And both of those heads of loss were not certified because the CAT said, well, hang on a minute, you have to have a factual focus upon the class members, and you haven't got a methodology that does that, so we're not certifying it. In fact, if you were to go back to the judgment, I hope that may still be open or convenient to you, at judgment 92 below, the CAT says in terms as regards compound interest, I don't have time to show you both, but compound interest, it says in terms, at paragraph 92, as regards the UKTC claim, I'm reading the second sentence, Dr. Lillico does not include a proposal as to how to estimate the entitlement to what is a distinct head of loss on an aggregate basis across the class. We do not find that surprising, since it would be very difficult to do so without information as to the financing of the diverse businesses carried on by PCMs. So that's a very similar question to the one that was raised in Sainsbury's. You have to focus on the PCMs when you ask yourself, well, what would they have done with the money if they hadn't been overcharged? Would they have invested it and therefore lost out on compound interest? Would they have spent it on something else, etc.? And it failed because there was no methodology. Because the CAT here correctly said, look, you have to focus on the PCMs. Right? And the same thing happened in the emissions technology. The reference there is Judgment 87. You would have had to ask yourself, what was the typical use of a truck? And the CAT said, well, you haven't done that. You have no method for doing it, so you can't proceed. And what we respectfully say is that the CAT should have done the same thing when it came to downstream pass-on for the same reasons. You have to focus on the PCMs. You have to get data out of them. You have to have disclosure from them. You have to have all kinds of factual analysis about what they are going to do in their business at a given time in a given competitive environment, and it didn't happen. And what we say then, there's another problem that I won't develop in the light of time, but as per our skeleton, we also say that the CAT failed to recognise, as regards downstream pass-on, that there are potential conflicts of interest. I'll just identify them for you and give you the cross-reference. It's our skeleton at paragraph 23, and they're very simple. They are, for instance, that the orthodox economic methodology for downstream pass-on is it tends to happen, or tends to happen more effectively where it's very competitive. But that gives rise to a potential conflict between all of these different PCMs. Some of them might say, well, actually, I want to dispute that this was a competitive market, but others won't. And that's because some of them, amongst other reasons, may say, well, actually, it suits me if this pass on because then I've got a better loss of volume claim. There are all kinds of permutations, but the point is because you have to focus on these individuals that the CAT didn't.
Does that really arise in an aggregate damages case? We had this rather in McLaren when it was clear that downstream you may have a variety of different purchasers, all of whom might be in slightly different positions vis-a-vis their negotiating power against the seller. But in an aggregate damages case, you're smoothing off those differences. You're coming to a global. I'm not saying it's necessarily a bad point, but it's not quite as straightforward as it.
But therein lies the rub, my lord, because you say what you infer, if I may politely put it like that, a sort of a global methodology that smooths things off. But it need not be like that. Look at Dr. Davis in the RHA. He's got multiple different regressions within. And
you can break your subclass or your customers down into categories, of course.
There lies the conflict, a potential conflict.
I see, okay.
Because somebody might say, oh, it suits me a lot better on the facts of my case to have a slightly more individualised approach too.
Okay. I see that when it comes to the subcategorisation.
And all I'm saying, I don't want to overstate my case.
No,
I don't want to overstate my case. I'm not saying that it might not be ever capable of being done. I'm not saying there is no aggregate top-down opt-out claim in which you couldn't, none of them you could ever address downstream pass-on a plausible, realistic aggregate base. I'm not saying that. I don't have to say that. All I have to say is that
you could have a case, for example, where you had evidence, or the expert produced evidence that everybody in the market reacts in a particular way to an overcharge.
And if there was some evidence of the availability of that data at the pass-on, at the certification stage, a point I'll develop after the short break, then that might suffice. Anyway, the point is I don't have to say you can never do it. All I have to say is that it didn't happen here.
You've got a whole load of different truck owners whose reaction to an overcharge would be necessarily very different.
Exactly so, and that's what our evidence did say. It's not as though this point came as new or a surprise. And just to finish off, and then then we'll take, if with your permission, a short break. Is that as I shall develop after the short break, this issue of downstream pass-on was one on which Mr. Thompson's client's expert, Dr. Lillico, was instructed not to address it. Right? So he didn't address it. It's not in any of the 4 reports. He put in 4 expert reports, and this is not in any one of them. So the only time that this was dealt with was in oral questioning at the hearing, and I shall come back to that after the short break. So unless I can assist further on the first respondent's notice ground, what it summarises is, as the CAT itself said, where there isn't a methodology, this is judgment 88, where there isn't a methodology that credibly and plausibly deals with the issue, the common issue, at the certification stage, it is not a common issue. We agree with that, and that's my case. The reason that this was an error of law is not a common issue because there wasn't a methodology that could address it, and that's because, although I don't need a reason for why the error was made, it's because they didn't fully appreciate that there's a big difference between the Merrick's pass-on situation and the Sainsbury's pass-on situation.
Okay, well, let's have a break for 5 minutes then.
Yes, thanks.
I'd say to tell them. I'm sorry? You just need to handle this one. Okay, no problem. That's all right. Was that constructive? Sorry about that sentence.
No, that's fine. I'm just going to read it from that. Thanks.
I just stand and wait till everybody comes in. Roger, you'll say.
Right?
Sure.
Yeah, I think Grant a whole I think he told me afterwards it was actually
Thank you, my lord. So I'm about to turn to Respondent's Notice Ground 2. The passage I was just struggling to locate as we left the
Just
room.
before you do that,
I beg your pardon.
I was grateful for the opportunity to have sort of time to think. Can I put a alternative thesis to you? I think I understand what you're saying, which is that in certain cases, of which Merrick's was an example, if you are the end user at the end of a chain, you need to demonstrate that an overcharge at the start of the chain has been passed to you to form the essential element of your loss.
Or to anybody at that level, any part, yes, you have to do that. You don't have to show all of it at certification.
Right. You say this is different because the claimants are at a different part of the chain. They're not end users. They are people who bought trucks, and on the hypothesis we are dealing with, they were overcharged by manufacturers for those trucks. So they suffered a loss. Now, at some point, the manufacturers are going to plead a defence, which says, yes, but they passed on that overcharge to their customers.
Yes, Mark.
You haven't yet done that.
We haven't yet done that because of the way the procedure operates.
Right. This is where I'm headed. You see, at the certification stage, why should the methodology have to deal with an unpleaded defence, even one which it can be seen is very likely to be raised? Why cannot that question be addressed by the CAT as and when the defence is raised as an exercise in case management? Why does the certification stage need to preempt all the defences that might be raised by manufacturers, leading to a sort of phony war in the absence of a defence? That's the sort of first issue. Now, I understand that you say, I think additionally, look, this pass-on that we know we're going to raise is not suitable to be tried as a common issue, because how individual truck owners may have passed on the overcharge to their customers will be so fact sensitive, person to person, business to business, that it's just not going to be suitable for determination as a common issue. And to which I say, or I put to you, why cannot that question, again, when it arises, be addressed by the CAT as part of its case management of the process, if necessary, going so far as to amend the collective proceedings order, or direct the trial of various sub-issues involving subgroups in light of the way that it is actually put. And my overriding question, and I'm glad you're writing them down, I'm sorry it's a very long series of points, is why does any of this amount to an error of law? Why do you say that the CAT erred in law, or would have erred in law, in certifying the UKTC claim for failure to deal with these defence issues, if I can put them that way? I hope that was a sort of long and rambly question, which you would, if you were in my position, have criticised for being a long and rambly submission. I hope it makes the
At the risk of
point
making it
reasonably
even
well.
longer and more rambling, I just raise a point, sorry.
Go on, finish
a point in that context, which is that I think in Sainsbury's, the Supreme Court said, well, this is an issue of mitigation, which will require the claimant to give disclosure. And if the claimant doesn't give disclosure, then the court might very well draw adverse inferences from that. So translating that into the present in my Lord's example, where at a later stage the CAT is dealing with case management, and it's faced with on this hypothesis, the UK trucks opt-out regime, I can put it that way. But you satisfy them from your pleaded case that there is a serious issue of whether they've mitigated their loss by passing on. they're going to have to give disclosure from somebody, and if they don't give disclosure from somebody, then they're going to lose. And when you ask, well, who's the somebody going to get it from? Well, you can legitimately say there may be problems in their identification of the members of their class. You've already made that submission. But by one route or another, the CAT would put in place a regime of sampling of some kind, rather like the one that Dr. Davis is suggesting. Sorry, I've given you yet more to think about, Mr. Harris.
Well, and here I was naively thinking that Lord Justice Green, have you got a fifth?
I was tempted, but I won't.
Right, well, let me try to deal with those
Just wait till your second.
questions before I move on. First of all, phony war. This is very much not a phony war. This litigation for these two proposed collectives is being...
Don't seize on that expression, because what I meant there was simply you're doing it in advance of actually filing a defence. I'm not suggesting in any way that the respondents don't have a legitimate concern about the sort of shape of the juggernaut that might be being launched at them. Don't
Yeah,
take stuff out of context.
I will leave aside that label because I didn't mean it in that sense either. No. What I meant by that was it is inevitably going to be the case in this litigation that there will be defences of pass-on of both types raised. So there's resale pass-on, selling the actual truck,
Yes.
and downstream supply pass-on.
Which is the second one, is the one you've been specifically identified.
More particularly focus upon that because the problems of the need for factual evidence and it all being bespoke and differentiated are more acute. They're not limited to that type, more acute. So what the CAT said in, I think, 155 that I began at the beginning by showing you the judgment was, let's not pretend this isn't going to happen. It's right that at the procedural stage under the rules, you haven't yet pleaded a defence, but you do object. You are allowed to put in objections, and we did. And one of the objections was, hang on a minute, you've got no way of dealing in your aggregate opt-out with inter alia, downstream pass-on, or pass-on of both varieties, but including downstream supply pass-on. So it was very much there on the, if you like, pleadings. I accept that it's not called a defence at that stage, but they are pleaded out objections to certification. One of them was, you've got to have a comprehensive view of the whole when you're doing an aggregate opt-out, because otherwise, and this takes me into an answer.
Well, okay, just pausing for a second, it's not pleaded out. I mean, I come to this with some prior experience of sitting on this type of issue. It's not actually pleaded out, it's been raised in a formal document,
yes,
you say, as something which, as and when you do put your defence in, will be pleaded out.
Absolutely, I accept that. But to some degree, the proof is in the pudding, although I say there's not much relevance to the Royal Mail.
I don't doubt you're going to raise these points, but in terms of just the coherence of the process,
yes,
and what we're doing at certificate, what the CAT is doing at certification stage, why do you say it's an error of law for the CAT, in the hypothesis we're dealing with, to have to said it would have certified the UKTC claim had it not preferred the RHA for this reason?
Well, that's a slightly different part of the answer, and let me deal with it straight on. In the CAT judgment, in a passage that 92, paragraph 92 of the CAT judgment, we say correctly, and this part is not appealed against, so there's no suggestion that this is wrong. At the end of that paragraph, we think it is appropriate. So in merits, what had happened was they didn't accept compound interest, but they didn't say it wasn't a common issue. They ducked that question with great respect to the CAT. But in contrast, the learned chairman of the tribunal in Gutman went a stage further with his colleagues in Gutman, says at the end of 92, however, having reviewed the principles governing a common issue, we think that it is appropriate to conclude that the claim to compound interest, these are the key words, cannot qualify as a common issue in the absence of a plausible method of estimating the entitlement to it on a common basis, either for all or for an identifiable part of the class. So my submission is, where there is no plausible method of estimating the entitlement, it is not a common issue. That's the conclusion of law reached by this tribunal in Gutman, and it wasn't appealed in Gutman, and it's not said to be wrong. And we go back to, I beg your pardon, I'm getting my cases confused. This one wasn't appealed by UKTC in this case. So this was the tribunal finding in this case. I do apologise.
No,
It doesn't matter, it's the same point. It's not,
Okay, but
it's not.
sorry, wait a minute. If you can identify something which is a common issue, but there's no methodology to deal with it, then it simply fails at certification because you haven't produced a plausible methodology to deal with something which is a common issue.
Well, no, my lord, because this is what the CAT is saying in this case on a non-appealed point of law. It's saying, as a matter of law, unlike how we dealt with it in Merrick's, where we just said it's not suitable to proceed, in this case they are saying it is not a common issue in the absence of a plausible method. So that is a conclusion of law.
Well, am I bound by that?
Well, my lord, that is not appealed. And there's no suggestion, nobody's ever made a suggestion that that is wrong and is not appealed. And the point is, it's very, very similar to Merrick.
Just a conclusion on the facts.
Well,
It
with
could just
respect,
be
we
a-
say no, but
It could just be a
in a-
random
in a way it
statement
doesn't
in the
matter.
decision, which, I mean, going back to a point we raised earlier, actually technically you're supposed to appeal orders, not statements and judgments.
my lord,
I know the CAT seems to have its own sort of modus operandi in that respect, but
well, my lord, in a way, in my respectful submission, it doesn't matter.
The appeal orders.
I'm sorry?
That's one of the reasons why you do only appeal orders, as opposed to what people say in judgments.
Well, my lord, we are where we are as regards
We
to
are
that
where
was
we are.
dealt with yesterday. In a way, with respect, I say that it doesn't really matter because it was a similar issue in Merrick's, a failure properly to analyse whether a question of pass-on was a common issue that was undoubtedly a point of law. It went all the way to the Supreme Court. So what we say is a failure properly to analyse, in the manner that I described before the very short break, why downstream pass on with its exclusive focus upon the passing on person is different from Merrick's. That was what I say was the misdirection of the CAT in this case. That's the error of law, and it goes to whether or not they were right to identify something as a common issue or not. They did say that downstream pass on for UKTC had just about scraped over the line as a common issue, and what I'm saying is that was a wrong conclusion as a matter of law. So in the same way that Merrick's, the CAT, identified something as a common issue and was said that was wrong, that's what I'm saying here. They identified in this tribunal in UKTC that it was a common issue just, and I'm saying it's wrong. So that's the error of law. But trying to deal with some of your other points, my lord, Lord Justice Snowden. So you put to me that it's very fact sensitive and can it be dealt with at a later stage? And I say no, because this is a gatekeeper role that the CAT and then reviewed by this court has to take very seriously. This was points that were made both in Merrick's at the Supreme Court and by Gutman by this court. And where you can see that there's already
we also made them in McLaren.
And absolutely in McLaren. So it's a consistent
I haven't
theme.
lost sight of that. I mean, the question is whether it's an error of law going to the certification or not, as it were, to have a methodology dealing with a potential defence.
Yes, and the way I put it is this, and hoping not to repeat myself from earlier, is one of the jobs at the gatekeeper stage, which is to be a task to be exercised vigilantly and diligently by the tribunal reviewed by this court, is to make sure that there won't be a procedural car crash. It's a procedural examination at the certification stage. And what I say about this case is because per Sainsbury's in the Supreme Court, many other cases, downstream pass-on is such a fact-sensitive issue, and because we can already see at this certification stage that there is no method capable of plausibly, credibly, and grounded in the facts dealing with it, that's where you can already see the car crash. And that's what needs to be weeded out. Indeed, that's the quintessential function, in my respectful submission, of the tribunal at the gatekeeper stage.
I thought, and I'll be reminded if I've got this wrong, it's possible I have, that in McLaren we didn't say that it shouldn't have been certified, but the CAT should, the error of the CAT was not immediately to grapple with the issue thereafter and just simply say, oh, it's a matter for trial. But I don't think we actually set in the ground that the cat shouldn't have certified.
That's correct, my lord, you didn't, but
There is a tension here, which we're very aware of. On the one hand, we want the CAT to grapple with these issues, and we use the expression a blueprint. On the other hand, we don't want to set too high a threshold, and we realise that the CAT has a really difficult balancing exercise in each case to determine what level of detail it requires of the parties. And that rather suggests it has a broad discretion. It would be rather ironic if in the Crown we said you haven't got far enough, but in other cases we said you've gone too far. In deciding what level of detail they're going to require of you, the parties, there's got to be quite a broad margin of discretion. Otherwise we end up tinkering and over-interfering with what is a very, very difficult balancing exercise for them.
I do accept that, but what I've tried to identify is a hard-edged conceptual error here, which is failure on the part of the CAT to recognise, with respect, that there is a difference of kind between downstream pass-on with the focus on the PCMs on the one hand versus a Merrick's type case where there was no focus of any kind upon the PCMs, and there never would be and there never needed to be. This case contrasts sharply with that case. And all I'm saying is where the error of law arose was that instead of recognising that difference and then holding UKTC's feet to the fire and saying, well, you've got to have some way of dealing with it, it said, oh, look at Merrick's. However much the difference is, it still can qualify. That's the error. That's the point. And you can see it at this stage.
So if the CAT had said, well, we recognise that this is different from Merrick's and fact sensitive, and your methodology doesn't deal with this, but we, the CAT, think that this is a matter that can be dealt with at the next stage, as it were, as a matter of case management, when there will be issues, when it's all been pleaded out and disclosure has been given, then in those circumstances, that wouldn't be an error of law, would it?
Well, I'm not sure I completely agree with that, my lord, for this reason, that you've got to, per 118 of process, which I recognise is not a statute, and we don't read it in that way, but nevertheless it says, and I paraphrase, that you've got to have something credible and plausible grounded in the facts at the certification stage. So it's not good enough for somebody to come along and say, I haven't dealt with this at all, but don't worry, because later on I'll be able to deal with it.
Well,
and it's essentially what happened in this case.
It's not a statute then.
No, I accept. But it's not a statute, but it plays into the whole thesis of there being a meaningful gatekeeper role. As your lordship said in Gutman, I think at paragraph 62, it's not a toothless test. And what the problem here is, there was no recognition, either by UKTC or by the tribunal, of the fact that there is a conceptual difference between downstream pass-on of this variety versus the variety in Merrick's or that was talked about in Sainsbury's.
But this is a defence in this case. Your downstream pass-on in this case, our current case, is a defence to somebody who has said, look, we have suffered loss, we have a claim because we were overcharged at point of purchase. The pass-on, so in other words, they've got a claim, they've established a methodology for, on this hypothesis, for an opt-out collective proceeding for all the purchasers of new trucks. Simples. I mean, look at the commission, look at the decisions, that's it. For certification purposes, why do they have to go as a matter of law further and say, and we have a methodology that can deal with whatever defences, which we have to anticipate now, can be thrown at us by the defendants?
Well, it's for the reasons that I've been attempting to elucidate, my lord, which is that you can, it's an integral part of the claim. Everybody knew there was an integral part of the litigation that there would be a defence of both types of pass-on.
Yes.
And because they chose to proceed in an aggregate top-down, opt-out manner, inevitably you could see at certification that would have to be dealt with. And because they chose to proceed in aggregate, top-down, opt-out, they had to have a procedural way of dealing with it. And that contrasts with RHA.
Just wait a moment. But is the true analysis not that they have to have a way of dealing with it, but you have to show, to avoid them being certified, that there is no conceivable way that they they can deal with it on a common basis. They can't produce a methodology because where's the burden here? Aren't you effectively saying that it's for the defendants to show that there is no conceivable way that they can produce a methodology at any time to deal with that point, therefore the thing must fail? Why do they have to prove at the certification stage that they can deal with or have a methodology to deal with every big defence, little defence, intermediate defence that might get thrown at them?
Well, my lord, there's a number of answers to that. The first one is we did make this point very clearly, and we did adduce expert evidence, and our experts, and I paraphrase them, did say, words to the effect of, we can't see any way in which this could be done in a credible, plausible, realistic, grounded in the facts manner, because it's too bespoke and individualised for the reasons I've already given. So first of all, we did do it on the facts, but I don't accept that that was a burden upon us as a matter of law. And so my second answer is, this tribunal, and again, I say a conclusion of law that hasn't been appealed at 155, said that it is not for them to produce a method by which this effect can be quantified on an aggregate basis. It's for the class representative. That's 155. I accept you may say to me, well, why should I be bound by that? Because I'm the Court of Appeal. But nevertheless, that was in my respectful contention, a conclusion of law that's not appealed. And this topic has been addressed by the learned current presidents of the tribunal in a different case, in terms, in the Gormson and metadata case. And I'll just show you that because it's not as though this hasn't been vexing the tribunal since the judgments in Gutman and, for that matter, McLaren. And it's being grappled with on a hands-on. You asked me, in a sense, about what practicalities. This is the learned president of the tribunal dealing with practicalities post those judgments. This is what he says. It's at tab 45 of the authorities bundle, which I'm afraid I have no idea which volume that is.
Volume 8.
I'm very grateful. Volume 8.
This is the Facebook case.
Correct, my lord, yes. And this exact issue is dealt with by the learned president and his colleagues at page 1899 of the bundle numbering, under the heading, the not my problem fallacy. It may be easier, quicker, my lord, if you were to just, your lordships, to read 189 that little Roman 2. So that effectively echoes what this tribunal. I'm so sorry, my lord. Yeah. And so what was said in Gutman. So
Well, sorry, and I'm just going to. The way that starts is often a proposed class representative will assert that it's not for them to make good, even in terms of blueprint points that will be part of the defence should the case proceed. I mean, I'm not entirely. I am questioning whether it is right to load into the certification test everything which is likely to arise or can be thought likely to arise in the proceedings, because otherwise it does produce the situation where at certification the respondents run out on a, as it were, trial basis, run out on a provisional basis a whole load of defences which they say they're going to want to run, and then criticise the class representative's methodology for failing to deal with them, and say it is actually for you, class rep, to produce something that deals with all these things. And then you get an explosion of expert evidence effectively arguing the toss around not the methodology for the claim, but the methodology for defences yet to be run.
We end up like the States.
well, my lord, let me deal with that in a number of ways. This is a central defence. and it has been run in terms in a case that went to trial. This is not spurious or peripheral. It's not de minimis. It's not in extremis. I do accept that as a matter of case management in running a certification hearing, if the tribunal took the view that there were some spurious or very left field or unlikely or whatever, proposed possible defences that are not really that realistic, it would disproportionate or improper to focus upon them, and therefore the class representative shouldn't deal with them. This is not that case.
And at the other extreme, I can certainly accept that if a respondent said, this claimant's methodology simply cannot be adapted at any stage to deal with a defence which we are going to run, that would be a flaw in the proposed claimant's methodology, because it just simply, you can just see now, in your words, that there's going to be a car crash in about 3 months' time or 4 months' time, and it can't be avoided.
But my lord, that is essentially what we are saying and did say in this case.
But you're saying critically that the burden lies on the claimants.
It is, but only in the process 118 sense. And this is, in previous cases, this has been described as not an onerous burden, but equally it is a gate, of which the tribunal is a gatekeeper, and it is not toothless. So it's not as though we are saying to them, you needed to come with Dr. Lillico and show us the precise methodology and exactly how it would work with whatever regressions and all the data. That's not it. We fully accept that it's only the same variety of onus upon them as for all the other elements of the claim. So it needed to show something that...
What did Dr. actually say about this?
I'm going to show you. This is the downstream pass-on point, is that he said not a single word in any of his four reports.
You've got that point.
So I'm going to go through the transcript.
reports because he wasn't asked to.
Absolutely.
So
But
he
that's
must
not
have
actually true. If Mr. Harris is going to make an assertion like that, he better go to the actual text.
Well, my lord, I could... It's absolutely clear.
That's why I asked the question, because you're trying to say there was an error of law by the tribunal. But if in fact Dr. Lillico had dealt with this, had provided a methodology, albeit one which wasn't as robust as it might have been, let us say for the sake of argument, then I have difficulty in seeing how you can say there's an error of law. Or an operative error of law, and it may be that they got paragraph 80 wrong, but it doesn't follow from that their decision was one which was turned on an error of law.
Well, my lord, I accept the burden that on respondent's notice ground 2, to which I haven't yet turned, there will be an issue for this court. I don't mind in the slightest, my lord. I'm doing my best. I do accept that if you are not with me, that what was dealt with in the transcript was insufficient, then I will lose on that aspect of respondent's notice ground 2. But what I do point out to you, and I don't have the time to turn it up, is that Dr. Lillico was not instructed to deal with downstream pass-on, and that's recorded in the judgment, that he didn't deal with it. I'll just ask my junior to remind me of the paragraph number in the judgment where it's recorded that it wasn't dealt with. But I can give you a reference to a judgment 156, I think. Just turn that up. Yes. Second sentence. Dr. Lillico had not been asked to address this in his written reports, and the instructions are supplemental tab 9 at 103. And supplemental tab 15 at 468, where it sets out that he wasn't instructed to deal with downstream pass-on, and that's unsurprisingly why he didn't deal with it in his reports. I do accept that there is some exchange on this in the transcript, and I will be dealing with that time permitting. But just to finish off, doing the best I can with Lord Justice Snowden and the court's queries, I do say that you can perceive now this forthcoming car crash on the facts of this case, because you can already perceive that there needs to be this factual focus in the Sainsbury's sense, and there is no attempt, no coherent, credible, plausible, grounded in the facts methodology to try to deal with that. There's just not. And one of the reasons there was not, and this is actually doing it in a sense to service to Dr. Lillico. There's no criticism by me of Dr. Lillico personally. He had to deal with this orally on the hoof because he'd been instructed not to deal with it in his reports. And then when the cat comes to ask him questions, as we'll see in just a moment, he has to say things like, well, I would have thought, and maybe, and probably, and my instinct is this, and the rest of it. But my suggestion and my submission is that's an error of law, because you can already see it now, and at the low burden of certification, it didn't pass that burden. That's my submission.
Just looking at Gormson, I mean, Gormson, when you read on, makes it clear that if this is going to run, you, the defendant, have to put your cards on the table, and in other words, almost put your defence up at the certification stage, because so that the extent and nature of your defence is clear to the CAT at that point. So I mean, that's the quid pro quo for the CAT actually grappling with it at the certification
Yes,
stage.
and
Your cards are on the table.
Absolutely, and I don't shrink from that, and maybe over the lunchtime or at the end of the day I can provide you with some references to reports. I don't think they're all in these appeal files because they weren't relevant. But we didn't just show up and say, oh, we think we might run some resale pass-on or downstream supply pass-on arguments. Our experts dealt with how that was difficult and how we couldn't see that being done on a credible basis in UKTC. So it dealt with that fairly and squarely, and notwithstanding that we had done that, Dr. Lillico was still not instructed to deal with it in any of his 4 written reports, and therefore he had to deal with it orally. So that's, and lastly, my Lord Justice Flo, you asked me about the adverse inferences point, but just finishing off on that before turning to RN2, we say with respect 2 things. It's not credible and plausible that in an aggregate top-down case that it should be disposed of on the basis of simply, oh well, there is no evidence produced by the people upon whom the entire focus lies, namely the PCMs, that they haven't been able to produce anything by way of evidence, and so therefore they should lose on the basis of an adverse inference. That's not, we say, not a realistic approach in a case of this type. But if I'm wrong on that, then that's another reason why we should have won at the certification in this case, because what your lordship put to me was, well, of course, if they don't produce anything, if they haven't got a credible method for producing anything, they will lose on the basis of the adverse inferences. And there we go, and they didn't have a method. So doing the best I can in the time before the short adjournment, can I deal with the respondent's notice ground 2? I venture to suggest that it may take another 10 minutes after lunch because of the interchange with the court.
We'll have a debate at 1 o'clock about where.
Very good. Let me rattle through. So the starting point on how we criticise the methodology is what my learned friend Mr. Singler took you to yesterday, which was the PTA ruling, paragraph 18, where it stated, and I quote, "The tribunal had significant concerns regarding the primary approach of UKTC's expert, Dr. Lillico." So everything that I say in this RN2 is against the background of the tribunal having these significant concerns about the methodology of Dr. Lillico. And it has 4 facets to it, this point. One of them is downstream pass-on, so I'll deal with that. The second one is Dr. Lillico's very belated reliance upon, quote, some sort of econometrics, unquote, and that relates to both overcharge and downstream pass-on. The third point relates to the lack of evidence of the availability of data, and I'll definitely deal with that given what happened earlier in this hearing. And finally, something that I may have to skip over in detail is he didn't have a method for removing inapplicable volume of commerce. But let me take them in turn. So Dr. Lillico, as I've said, was not instructed to deal with downstream pass-on, but he does deal with it in the transcript, so a point that I've been foreshadowing several times. May we please turn it up? It's in the supplementary bundle, tab 29, day 4. And in particular, if one were to turn in that transcript to page 1143, this is an interchange between the presidents of the CAT, the Honourable Mr. Justice Roth and Dr. Lillico, and this is where the transcript turns to the question of pass-on. I'm not going to have the time to go through this in detail, but can I just point out certain themes that emerge from, for example, Dr. Lillico from line 9 down to the bottom of the page. So what he says is that he has an instinct that there would be some. And then he says, line 13, I would have thought the natural way. And then at line 14, probably via
Hang on,
econometric.
this is dealing with used trucks.
This is a resale pass-on part of the
Resale, yes.
resale pass-on, precisely so. It's an aspect of pass-on, but I accept it's
but
resale.
we've changed from where we were previously, sorry, different sort of pass on, yeah.
Yes, because I'm going to deal with the transcript in order in which it came out in the
okay.
in the transcript, because otherwise it gets even more confusing.
So
he
the
says
basic point you're trying to establish is that it was recognised that some sort of econometric analysis was the natural way of doing it, should have been done, but wasn't.
Yes,
Is that the central point?
the central point is that it wasn't addressed in the reports. Then he was questioned on it because the CAT took the view, my suggestion rightly, that it had to be dealt with. And with respect to him, because he wasn't instructed to deal with and he hadn't dealt with it, he hadn't put a lot of forethought, let alone a credible, plausible blueprint on the point. He was a little bit hamstrung and he had to say, well, I would have thought this and my instinct in that and probably this and maybe that. And then he just, so far as we get on the downstream pass on for resale resale of trucks was line 23. Probably do some analysis of econometrics.
And your bullet
Sorry,
point is
sorry, you just said that's downstream.
This one is, downstream is both types. There's technically, my lord, there is supply pass on downstream and there's resale pass on downstream. They're both downstream.
I've in my head, I've got two types of quote to pass on. One is when you sell the truck,
Resale,
and the other is when you charge your customers for
Goods.
delivery.
Supply.
So
Right.
you've been overcharged for the truck, and you pass on to the customers through other means.
precisely.
the-
When
the
Royal Mail
cost.
sells its stamps, for example, it
You
overcharges
increase your
us.
costs or
Yes.
whatever.
Precisely.
Yeah.
They're both downstream.
Charges.
One is resale of a truck, the other one is you pass it on into the goods
It's
that
a
you're
different
selling downstream.
streams, perhaps. I
Maybe.
mean, but let's not.
Maybe. The headline point, my lord, was just very simple. He had to do it on the hoof. He did it by instinct. He did it by probablys and maybes, and he just says, "Oh, some form of econometrics." That's not good enough. No, on no basis can that be said to pass, with respect, in my contention, even a non-onerous Microsoft test. Although I understand why he found himself in such a difficult position, because he wasn't instructed to deal with it, and it's replete. If one were to look at this, you would see that it's replete with the difficulties that he had.
And did he explain at any point why you say he wasn't asked to deal with it? Because of course the class, the UKTC class, is just purchasers of new trucks.
Yes, it's because he was instructed that it wasn't relevant, and we say that those instructions were wrong. So it wasn't in a way his personal fault. His instructions were by his client that it's not relevant for us to be dealing with this possible defence. And the tribunal said, no, that's wrong. And the learned president in Gormton said, no, that's wrong. And the reason it's wrong is the one I've been trying to give, which is that's not a blueprint. It's inevitably going to happen. And it's not as though we didn't address it. We did address it.
Right. And so, but the question is, on who is the burden, as I still see it at the moment, is it for you to say his methodology, or there is no methodology that can conceivably deal with this, that can be accommodated at some later stage within the case management powers of the CAT to set the blueprint which changes to trial?
Yes.
Or is the burden on the claimant to anticipate the defences and actually put a plausible methodology in the same way they have to demonstrate that they've suffered loss?
And I accept that's an issue of law for this court to decide. You have my submission on which way the burden should lie. But what is clear is that in this case, even on the latter approach, let's say you were contrary to my client's interest on that point. So in the latter case, and as you formulated it to me, the proposed class representative has to have at least some plausible method. They didn't even do that. So even if you were against me on that point, they didn't even put forward a plausible method.
It boils down to this: you put up the defence. It wasn't addressed by the CAT, and therefore it wasn't addressed by the by UKTC. Ergo, the CAT should not have certified. And should not-
Yes.
Full
Yes.
stop. It should not have got to the point of saying we prefer Davis over UKTC, RHA, UKTC. That's the short point.
That's right.
But did you have any expert evidence that said you cannot simply, did you have affirmative evidence saying, from an economist saying, you cannot deal with this question by any methodology?
My lord, I'd have to check precisely how it was put. What I can recall, and this is not in the bundles, is that we did lots of the experts for the OEMs did identify all the profound problems that arose for downstream packing of both types in a case of an aggregate top-down opt-out, and they weren't dealt with. Whether at any point one of them went so far as to say there's no conceivable way of this ever being done, I don't know, but I wouldn't accept that that would be our burden in any event. But I can check and
And your experts say, because Dr. Lillico said at this point, oh, well, some analysis of econometrics.
Yes.
Your experts say, well, using econometrics just won't work in these circumstances.
Well, there's nothing for our experts to attack, because orally, having had no written report, at the last minute, in oral...
But if the question is not for them to predict your defences, but for you to say, there is no way that anybody can adapt, run, or in any way devise a methodology to deal with this particular defence. Therefore, it's an error of law to certify, because you can't run this as a common collective issue in a collective proceedings. You would expect your side to have, in effect, said, this is untenable. Look at our expert. He said you can't do it, and there's no answer.
If that were the law, then
At the moment, I'm testing with you whether it should be at certification stage.
and I'm saying no, and for the I appreciate we're slightly going around in circles here, because my submission is no, it shouldn't be, because it's a very low hurdle to begin with under Microsoft process. And when they can see this defence coming, all they have to do is have something credible and plausible, and these words, some sort of econometrics, on no view can that be said to satisfy something credible and plausible that if the test is not to be toothless. If it's to be toothless, no problem. But then, let me put the point another way. Dr. Lillico is allowed to show up, he's got a decent, I don't mean this in any disrespectful manner, he's got a proper CV, I'll put it neutrally. He's a perfectly respected economist. If he's allowed to come up and say, when he's confronted with, hang on a minute, you just haven't dealt with this at all. You just haven't dealt with it. And he's allowed to say, well, don't worry, because I'm an economist, I've got a good CV, I know how to do econometrics, I've done lots of it, I will do some sort of econometrics. If that satisfied process, with respect, what on earth doesn't?
Is the cat entitled to say this? We've got two economists. We prefer A over B. We're not going to get too worked up about the inadequacies of B. If we had decided that B was going to be the class representative and he was therefore going to be the economist, we would then have required more of him. But since we're not, we don't have to get too far into B's inadequacies. No need to wallop him and make him improve his work.
Well,
Is that what the cat did here?
well, my lord, there were two separate cases here. They were just heard together. And I'm entitled in my respectful submission to come and say, this went wrong in a respondent's notice type sense.
Yep.
Because although you said it just scraped over the line.
Okay, you're absolutely entitled to say that. I mean, we've been taxing both you and Mr. Snowden about why you're raising this point. You're entitled to say, because UK Trucks are saying to us, we should be part of the party. We should be running the new trucks bit.
Yes.
You're entitled to say, as one of the OEM representatives, well, no, that shouldn't be the case, because the CAT got it wrong in certifying them in the first place.
That's how I
They
put
should
it, my
simply
lord.
have chucked them out.
That's how I put it, my lord, yes. So it may be, so where we've
probably
reached,
a convenient moment to break.
it may be. Do you want to have a little bit of a roadmap? But
What I suggest.
We prefer a blueprint, sure.
What I suggest, yes. Will it satisfy the Microsoft test?
I certainly hope I can do that, my lord.
What I suggest is that you all, because I need to discuss with my colleagues what our availability is tomorrow. But I think you should all, we seem to be running at least an hour and 3/4 behind schedule, at least.
Yes,
I
Lord.
suspect more like 2.5 actually, which is half a day. Now, I could sit tomorrow morning at 10:30, but I can't sit beyond 1 o'clock, and I wouldn't want to sit beyond 1 o'clock. I'll discuss it with Lord Justice Green and Lord Justice Snowden. So assume for the moment that this case has to finish by lunchtime. What we'd like from all of you at 2 o'clock is an assessment of where we are and that it is feasible to do that. We can sit till 4:30, I think, tonight.
so that, if that helps.
I anticipate we will be able to do that with a 10:30 start and a no later than 1 o'clock finish, even with the degree of lateness so far.
All right, discuss it amongst yourselves.
Thank you very much.
Come back at 2 o'clock.